Welcome to EU Privacy for All, Session 19 on GDPR, Article 17, Right to Erasure and to be Forgotten. In the final draft of GDPR, the Article 17 still targets the right to erasure and the right to be forgotten. This article recognizes the existence of a right to obtain from the controller the erasure of personal data concerning a data subject without undue delay, meaning for the controller the obligation to erase personal data without undue delay where one of the 6 following grounds applies. First, the data are no longer necessary in relation to the purposes initially identified for the collection of data. Second, the data subject withdraws consent. Third ground is the fact that the data subject objects to the processing of personal data. Fourth ground, the personal data have been unlawfully processed. Fifth, the personal data have been erased for compliance with a legal obligation in the Union or in Member State law. And the final ground is the fact that the personal data have been collected in relation to the offering of information society services. According to the second paragraph of Article 17, the controller making the personal data public will have the obligation to take reasonable steps, taking account of available technology and the cost of implementation, to inform controllers which are processing the personal data that the data subject has requested the erasure by such controllers of any links to or copy or replication of those personal data. Those obligations shall not apply to the extent that the processing is necessary for exercising the right of freedom of expression, for compliance with a legal obligation, for reasons of public interest in the area of public health, for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes, or finally for the establishment, exercise or defense of legal claims. Let's focus now on different provisions in the GDPR, precising how to implement this right to be forgotten. First, in Recital 39, it is stressed that time limits should be established by the controller for erasure or for a periodic review of personal data. In Recital 59, modalities should be provided for facilitating the exercise of the data subject rights under this regulation. As already stressed in Article 17, Recital 66 raises the point that a controller making the personal data public will have the obligation to inform the further controllers of their own obligation to erase any link to or copies or replications of the personal data erased, taking into account available technologies and the means available to the controller. Member States will have the possibility to provide further specifications and derogations to this right, as announced in Recital 156. Articles 13.2b and 14.2c raise the point that the controller shall provide the data subject with information regarding the right to erasure of personal data. Additionally, in Article 58.2g, it is stressed that each supervisory authority shall have the following corrective powers, including the one to order the rectification or erasure of personal data. The directive does not include any kind of individual right to be forgotten, written as such. However, there is a right to erasure that is provided in Article 12b and c, where it is mentioned that any data subject will have the right to obtain from the controller the erasure of data, the processing of which does not comply with the provisions of the directive. It also includes the obligation for the controller to notify to third parties to whom the data have been disclosed of any erasure of data, unless this proves impossible or involves a disproportionate effort. What should accountable data controllers get prepared for? First, they should guarantee data subjects a right to obtain the erasure of personal data without undue delay, whenever data is no longer necessary, or the data subject withdraws consent, or the data subject objects to the processing of data, or the processing is unlawful, or in the frame of the application of legal obligation, or finally, if the data have been collected in relation to the offering of information society services to a child. Data controllers will also have to ensure fair information of data subjects regarding the right to erasure and to be forgotten. And they will have to set time limits and periodic reviews so that erasure would be implemented appropriately. They will have to facilitate the exercise of data subjects' rights and take any kind of reasonable step to inform other controllers processing the data that the data subject has requested the erasure of any links to or copy or replication of his or her data, taking account of available technology and the cost of implementation. Additionally, data controllers should bear in mind that these rights shall not apply if processing is necessary to freedom of information, compliance with a legal obligation, or for reasons of public interest such as public health, archiving, or statistics. Finally, they should check whether member states will provide restrictions, derogations, or specifications to this right. The key question raised regarding the Article 18 and the right to be forgotten is knowing more about EDPB, the European Data Protection Board, or court's guidance on topics such as reasonable steps to be taken by the controller.